So, good morning, everyone. Welcome to this conference on corporate environmental responsibility. We will have 4 panels today. In the morning, we'll have 2 panels dedicated more to a public law perspective, and in the afternoon, more to a private law perspective. But of course, environmental law is cross-cutting, so everything is of matter to us here who study environmental law. And we will start with a panel dedicated to corporate environmental responsibility under international law. First of all, with Elisa Morguera, who I know is online and hopefully will show up soon. Oh, hello, no, got it. And Elisa Morguera is from the University of Strathclyde, Glasgow. She has a PhD in international law from the European University Institute, and she's a professor of global environmental law at the University of Strathclyde, Glasgow, and also an adjunct professor at the University of Eastern Finland. She's the author of a very well-known book, I think, at least for me, on corporate environmental accountability in international law, published by Oxford University Press, which of course is the reason why we asked her to join us in today and to give us her feedback on this very, always hot topic on corporate environmental responsibility under international law. Elisa, thank you very much for being with us, and the floor is yours now.
Thank you so much for the invitation. I hope you can hear me well.
Yes, we can. Thank you.
Great. I'll share my screen now, so hopefully that also goes all well at your end. Yeah, so I'll take, I think, around 20 minutes, if I'm correct, to provide an introduction to the development of international standards on corporate environmental accountability in international law. For a very long time, since my PhD days, I've been interested in the role of the United Nations in developing those standards and clarifying the role of the private sector vis-a-vis international environmental treaties and principles. And looking both at, this historic development, just to provide a background for the discussions today, as well as some very recent developments and challenges, on some of which I'm still wrapping my head around. So I'll be curious to hear what the colleagues in the audience think about. So as I said, just starting with a little bit of historical content, maybe it's helpful to know that from the very start of international environmental law, if we take the Stockholm Conference on the Human Environment as the symbolic birthday of international environmental law, the international community has been wondering and trying to pin down a role of the private sector as part of the broader international community beyond states to contribute to the realization of international environmental objectives. And each and every major UN summit focused on the environment and the progressive development of international environmental law has done so in gradually in more detail. The Rio Conference was quite significant in devoting a whole chapter of Agenda 21 to the role of business. And perhaps the 2002 World Summit on Sustainable Development has been the summit where we discussed more in detail, and maybe with a hope of more groundbreaking terms, the duty of the private sector to contribute to environmental protection. In fact, at the time, environmental NGOs were even hoping that there could be a launch of a treaty negotiations on corporate liability. So really putting as much legal flesh as possible to that idea of the role of the private sector in international environmental law. The proposal was unsuccessful, but we have some significant language in the outcome documents of the World Summit on Sustainable Development, which clearly indicate how the international community of states were not willing at the time, and perhaps many still continue to oppose the idea of developing instruments in international law on the liability of private companies, but are open to discuss ways in which we can clarify the accountability, how we can still hold in some ways, maybe in soft law ways, accountable private companies vis-a-vis the terms of international environmental law. There were hopes that the Rio +20 conference might have provided more details on this and perhaps take stock of the parallel developments related to business responsibility to respect human rights, which I'll discuss in a second, but it wasn't quite the case. And even if one of the dominating theme of the conference was green growth, and so very much trying to look at ways to reframe the understanding of the role of the business sector under international environmental law as a positive role of providing opportunities and maybe innovation in terms of realizing international environmental law objectives, as opposed to looking at the dark side of limiting environmental damage arising from private sector activities. Even that term and that agenda didn't achieve, I think, global support and remains a contested term. So on the one hand, this is a theme that comes from the very origin of the development of international environmental law, but remains, I think, an area of contested understanding. And when we have that kind of like push and pull in terms of how international environmental law is developing. In parallel, we've had since the 70s, various international processes, not only under the aegis of the UN system, but also of other international organizations that have tried to pin down, again, the expectations of the international community with regard to the role of initially mainly multinational corporations, but later on also other business sector, other business enterprises in relation to international law. And it's important to keep in mind that those efforts started in the process of decolonization and really trying to recognize the continued power of former colonizing powers through the economic activities of their own companies abroad. The first attempt of a code of conduct from transnational corporation, and you can see it was a very lengthy negotiating process, even for a soft law document, ended in a collapse of the negotiations and very much marked, again, really, I think symbolized that difficulty to achieve a common view across the community of states around that understanding of the role of transnational corporations and other companies in terms of international environmental law. And so within the UN, we had various different approaches to try and kind of overcome that major setback. And maybe the most successful initiative since then had been the Global Compact, so very much moving away from the idea of an international regulation and rather looking at partnership, again, trying to focus on the positive contribution that the private sector can make to the realization of different objectives. And increasingly in the early 2000s, we start to see a dominating frame of human rights. Again, with like alternate, I think, successes, the development of really important and interesting instruments, such as the UN norms on the responsibility of transnational corporations and other business enterprises, which, however, were effectively in between the lines rejected by states or the majority of states, and eventually landing on what has been considered a diplomatic success, at least, which is the UN Framework for Business and Human Rights and the guiding principles, which have provided that understanding of business as business responsibility as an understanding of international law is relevant for how business operates, even if it is not directly applicable or doesn't directly strictly bind business entities, but it does affect the way in which they evaluate their own risks and the way in which they relate to the communities in which they work with, including above and beyond what may be required of them by national law to which they are subject to. And of course, there's treaty negotiations ongoing at the moment. I think the next speaker will talk about that. And again, this picture just shows how that kind of continuous push and pull, trying to kind of stop this conversation at a comfortable place for at least some states, and notably, I think the states that are home to transnational corporations, and instead that push for the further development of international law, so as to more directly apply or relate to non-state actors such as business enterprises. But the UN, as I said, has not been the only place for those discussions. The OECD, again, since the 70s, was actually a relatively successful venue in which mainly capital exporting states have been able to agree on a set of recommendations for multinational enterprises, the guidelines for multinational enterprises, which remain a really significant and influential tool both for states and for businesses. And yet in another place, which maybe is less familiar, within the World Bank Group, the International Finance Corporation, which is the arm of the World Bank that lends money directly to private companies, we also have a set of what they're called performance standards, which try to encapsulate those expectations of good business conduct based on international environmental law as a basis also for some legally mandatory approaches in terms of the provision or the withdrawal of financing that can be allocated by the IFC. So what's interesting here is to think that in every single one of these initiatives, there was always at least a section devoted to the environment. So that kind of parallel interest that we saw within the international environmental law community was very much mirrored in the context of all these initiatives across the UN and other international organizations. And the significance of those efforts, whether or not they survive the test of time, is that we can see the effort to translate international environmental law, which of course has been conceived as an interstate tool and in interstate language, into standards that make sense for business enterprises and provide meaningful benchmarks for conduct in the private sector. As I said, with the UN Framework on Business and Human Rights, we finally land to a place that is comfortable for, we can say, probably the totality of the states in the international community, and where I think the very kind of diplomatically subtle use of the notion of due diligence, which is familiar to public international law, but is in fact used very much from the perspective of familiar terms in the business community, has provided a container for including those translations of relevant international law, particularly international human rights law, into a process that already exists within private companies. So assessing the risks and adapting their management approaches to that ongoing assessment of risks, as well as then communicating those risks and relating to the communities they work in. And within that body of work that John Ruggie, the special representative of the UN Secretary General on Business and Human Rights, we have also a documentation of that sense of push and pull, that understanding that there is an emergence and expectations around a clearer relationship between international law and particularly international human rights law and business, but yet not a relationship where we can draw very clear lines. What is interesting from our perspective is that while the UN framework and the guiding principle on business and human rights have very much reframed all the efforts across those international organizations I just discussed, and we had revisions of the OECD guidelines and also the IFC, which spoke to and referred to then the language and the approach of the UN framework on business and human rights, we didn't see all that body of work and understanding of the importance of the environment as part of business responsibility explicitly discussed in the UN framework and the guiding principles, even if in its own work, John Ruggie, in assessing what were the main causes of concern in the international community about the role of business, the environmental cases were the vast majority where we would see violations of human rights in the context of environmental harm caused by private companies. So in a way, it was a missed opportunity to kind of connect or reflect an international process of decades where not only human rights, but also environmental issues were very much part and parcel of the concern that the international community had regarding the private sector. But even without that reference to environmental issues and standards, we can see how the framework relied on notions that are very familiar and in fact were developed within international environmental law, most notably impact assessment, but also the ideas of the kind of the life cycle approach to management. So there was something that was kind of underneath the surface, but not made explicit in the framework and guiding principles around the importance of business due diligence to respect human rights, also from the perspective of international environmental law. So what's been interesting anyway is just to see how even with this like different processes of development of international standards on corporate environmental accountability, their content is quite overlapping and common in previous initiatives under the UN, as well in the OECD and IFC standards. We see very much a reliance on general principles of international environmental law to again, forge those workable benchmarks of conduct for the private sector. And in terms of the procedural dimensions of this principle, we can see how they speak quite clearly and neatly to the idea of due diligence that Raghi included in his own framework approach. And more gradually, I think standards also emerging in relation to biodiversity and climate change and efficient resource use. But I think this is a development that has really taken momentum only in the last 10 years, I would say. For the majority, I think from the 70s to the 2000s, there was really a focus on the procedural side. And more recently, I think there's been a need to clarify business responsibility with regard to those substantive areas of international environmental law. Quite a lot of work has happened, particularly in relation to business responsibility to respect indigenous people's rights vis-a-vis extractive activities on their traditional territories and sacred sites or negatively affecting those sites. Increasingly also in relation to activities for conservation, which may involve the private sector. And without going into too much detail on this slide, is just to show that there's a really interesting area of cross-fertilization between the work that the parties to the Convention on Biological Diversity have done in developing guidelines to explain the protection of indigenous peoples and other communities, particularly through environmental impact assessments that include also sociocultural elements, but also in relation to free, prior, informed consent and fair and equitable benefit sharing, and reliance on those guidelines, which are addressed both to states and non-state actors by a series of international human rights experts that have developed that understanding of business responsibility to respect indigenous people's rights. And you see that in the corner of the slide. And this has really been something that has then been captured in the 2018 UN Framework Principles on Human Rights and the Environment, in relation to states, but then in other guidance by the UN Special Rapporteur on Human Rights and the Environment, also in relation to business enterprises, and very much filling with content or showing the importance of those developments for understanding the framework principles, the guiding principles, in the context of indigenous people's rights. And that has really been building upon the work that the former UN Special Rapporteur on Indigenous People's Rights, Professor James Anaya, did. He was really the first to react to the adoption of John Ruggie's guiding principles to say, okay, we need to be explicit about the standards of corporate accountability in relation to the environment, with a view to ensure protection of indigenous people's rights, because these are really the cases where you can't escape an engagement with international environmental law with a view to protecting indigenous people's human rights. And he really developed through a series of reports a very detailed understanding of how we need to move away from current practices of almost like charity or one-way flow of benefits and very limited consultations with indigenous peoples, towards instead a whole frame of a partnership between private companies and indigenous peoples if economic activities are proposed on their territories. So I won't go into much of the detail of this, but just to show, as I said, how gradually this provides a much finer grained picture of that understanding of business responsibility at the intersection of the protection of indigenous people's rights and the protection of the environment, and particularly biodiversity. Now, where we move from there, I think there's still a lot that needs to be clarified. On the one hand, I think that understanding of those three safeguards for business responsibility to respect indigenous people's rights is increasingly emerging also about other human rights holders. There's the whole question of who are non-indigenous communities who can benefit from similar, if not the same level of protection. We have now the UN Declaration on the Rights of Peasants, so there's a question around the importance of that for understanding the body of interpretation of international law. But as I was saying, there's also a whole understanding of how business engagement in conservation and environmental activities, and particularly climate change measures, should be subject to the same set of measures and safeguards if it involves, for instance, indigenous lands and territories and potentially other areas of communities. But also more and more, I think what's been interesting for me is to see how then the recent recognition of the human right to a healthy environment and the recent interpretative clarification of the human right to science really show a much deeper understanding of how business need to respect and think through human rights at even earlier stages of their planning of activities. In fact, almost at the level of developing the evidence base on the basis of which decisions are taken about licensing certain activities or not. And that, to me, that early stage is really what most of the current issues in international environmental law about effectiveness boils down to. So this is just to kind of share a little bit. I don't know how many colleagues are familiar with the human right to science, but it has been invoked very recently also by the High Commissioner for Human Rights as a really important lens to understand what states and business need to do, also to protect everyone's human right to a healthy environment. So we're also kind of moving away. There's an element of this feeding into that due diligence to respect indigenous people's rights, but a lot of it really spills over into protecting everyone's human rights when the environment is concerned. And it has to do with questions related to technology transfer. And in fact, I would say taking that kind of early on approach, maybe technology development. It has to do with scientific cooperation and again, public-private partnerships in that context, and very much thinking about the role of science leading to choices related to either environmental protection or use of natural resources, which then has impacts on environmental protection, which in turn has then knock-on effects on human rights. And I think there's a lot of work to be done there in fully understanding the role and responsibilities of researchers and research funders, but also development funders and say climate funders in this context, and the role of business as well from that lens. There's also quite a lot of uncertainty still around understanding those existing standards related to business due diligence in the marine context. And this is because more generally, I think our understanding of human rights and the environment for decades has really very much focused on land. And it's only been in the last couple of years, I would say, that various issues related to the use of the ocean, but also the role of the ocean in our well-being, from regulating the climate to contributing to the oxygen we breathe and other conditions of human health and survival, has really become clearer in terms of also human rights. And so there's an issue around fully understanding the relationship between the protection of human rights and the protection of the marine environment, and within that, understanding business responsibilities. So we've seen a few questions popping up related to the role of foreign investors in the blue economy, looking at the role of, for instance, of large-scale fisheries from a business human rights perspective, looking at the problem of ocean plastics as an issue of business responsibility, which in fact brings us back to the responsibility of oil and gas companies, in fact, in producing plastics as part of their production process. And then the question of like climate action and how ocean-based climate action and technologies also raise issues related to business responsibility to respect human rights. And that, I think, synergy between everyone's human right to a healthy environment, indigenous people's human rights, and the human right to science, I think is really important lens to apply in trying to advance our own understanding of how the law of the sea and the evolution of international biodiversity law and climate change law then speak to and should be translated into standards for the conduct of business. On top of this, I also think it's really important to reflect on the role of the new general comment on children's rights to a healthy environment. I think that brings a whole other layer of clarification in terms of ambition of the role of business in respecting international environmental law and human rights, the time frame, considering how impacts on children have long-term effects and sometimes unpredictable effects. And so again, this is a whole area where I think more work needs to be done, both in the more familiar areas of corporate environmental accountability, as well as maybe to kind of leapfrog in those areas that have been lagging behind, such as the area of business responsibility to protect human rights in the context of the marine environment. And maybe my final thought is just to say that as part of the research I'm undertaking with my colleagues of the One Ocean Hub across marine and social sciences, what we've realized is really a huge bottleneck in understanding that interface between human rights in the ocean is how the still limited understanding of cultural rights and the variety of spiritual and cultural connections to the ocean, which may go well beyond visible uses of the ocean or say the deep seabed. And through understanding those cultural rights, realizing whose other human rights, civil and political rights, as well as economic and social rights might be at stake, including from the perspective of business due diligence. And so this is just to give you the example of a case in South Africa where through research on understanding indigenous knowledge related to the deep seabed, South African courts have not only recognized those cultural rights, but on that basis realized that Shell and several other oil and gas companies who had already licenses to use sound-based exploration techniques in the ocean had not carried out appropriate consultations with relevant human rights holders. So really interesting area of work where we really need to, in my mind, rethink also the role of legal researchers and academics in engaging with other disciplines and working together with different human rights holders and knowledge holders to develop ourselves a more holistic understanding of the relationship between human rights and the environment, and then translate that into clear standards for business and for anyone who is holding business to account. So I'll stop there and hope I haven't taken too much time to go through these slides.
Okay, let's give it a round. Okay, Elisa, no, you did not take too much time, and obviously very interesting, and I could feel Armando and Vladislava next to me, you know, having feelings and opinions, but we'll leave that for later. Now we'll listen to Chiara Macchi. I'm very sorry, but I do not have a Dutch pronunciation, so I'm just going to say Wageningen University and Research. I have heard it pronounced in Dutch, and it's impossible. So she has a PhD in politics, human rights, and sustainability from the Scuola Superiore Sant'Anna, and assistant professor of law and coordinator of education at Wageningen University and Research Law Group. And she's the author of the book Business, Human Rights, and the Environment, The Evolving Agenda, which of course is one of the main reasons why we thought it would be great to have you with us. So thank you very much, and the floor is yours, Chiara.
Thank you very much, and no worries about the presentation, everybody. Sorry, the pronunciation, everybody struggles with that. So thanks for the invitation, and thanks, Elisa, for the, as usual, very interesting presentation. Hopefully, I will give some complementary remarks about the concept of corporate environmental due diligence by looking at a series of instruments that have touched upon this concept or not touched upon this concept. And in particular, I will look at some international frameworks for the promotion of sustainability and, of course, the fight against climate change. I will look at the draft BHR treaty and at some business and human rights soft law instruments, and I will also mention a few developments under international human rights law. And if we have time, we will also have a look at the draft EU directive on corporate sustainability due diligence. So starting from the global frameworks, Elisa gave, of course, an excellent recap of how the role of businesses was already mentioned in the Rio Declaration or the Johannesburg World Summit on Sustainable Development. But of course, it was not matched by adoption of rules at the international level on the regulation and liability of corporations for their environmental or human rights impacts. As concerns the Paris Agreement and the Agenda 2030, I personally find a bit concerning that they mention in a very cursory manner, if at all, the standards of corporate responsibility that have been adopted under international soft law, and in particular the Paris Agreement, while making some reference to human rights, makes no reference to the UN Guiding Principles on Business and Human Rights, or in general to human rights responsibilities of corporations, while the Agenda 2030 only makes a very cursory reference to the UNGPs, the UN Guiding Principles on Business and Human Rights. I find this gap a bit problematic for several reasons. It suffices to think about, just as an example, the carbon offsetting projects that private corporations put in place, sometimes in partnership or in collaboration with local governments, especially in the Global South. And these projects, while being questionable from the point of view of their ability to actually produce net reductions of greenhouse gas emissions, are often associated with land grabbing, with violations of indigenous people's rights, with evictions, with loss of biodiversity, and so on. So I find it dangerous to stress the involvement, the much needed involvement of the private sector in the sustainability transitions without an equally strong emphasis on their responsibilities and on the frameworks that are starting to develop their human rights and environmental responsibility. As concerns the Business and Human Rights Treaty that Elisa was mentioning, this has been under negotiation for a few years, and in the late October 2023, so just a few weeks ago, the Intergovernmental Working Group held its most recent session for the negotiation of the treaty. However, the third draft of the treaty that has been published earlier this year, as you can see from these brief excerpts, has largely erased the references to the environment that were contained in the previous version. In particular, the explicit reference to the right to a safe, healthy, and sustainable environment has been erased at the request of some countries. Any reference to the UNFCCC or to the Convention on Biological Diversity and other instruments has been erased. The previous draft contained an interesting direct reference to the need to require corporations to put in place not only human rights impact assessments, but also environmental and climate change impact assessments, but also this reference has been erased from the latest draft. And so on. So I find it, again, a bit concerning that states apparently, or at least the international community, is not fully aligned in walking the talk when it comes to operationalizing the right to environment, also through this kind of business and human rights instruments. Of course, the BHR treaty will not bind corporations directly, but states, but it could be extremely important in clarifying indeed what are the specific environmental and climate change responsibilities of businesses that states should make sure are respected. Now, while the BHR treaty is not at the moment the most advanced in terms of recognition of environmental and climate change responsibilities, of course, at the international level, there are some interesting soft law instruments, and I will not spend too much time on the UN Guiding Principles on Business and Human Rights because Elisa has already amply touched upon this instrument. Of course, they make no explicit reference to the environment. However, it is interesting to note how the human rights due diligence concept that they have coined has then been translated into binding legislations in several countries. In France, for instance, the law on the duty of vigilance also entails an environmental due diligence dimension, and this is also expected of the upcoming EU directive on corporate sustainability due diligence. And the UNGPs have also been mentioned and referred to as an interpretative tool in several judgments that had to do with business-related environmental impacts and we're trying to clarify the obligations of states, and in the case of Milieu Defensive et Social, the climate change obligations of a private corporation. They also contributed to the emerging concept of parent company duty of care that in the UK has now quite consolidated in the jurisprudence through cases, again, environment-related cases such as the Vedanta and the Okpabi judgments. However, perhaps the most interesting development in the realm of soft law is the 2023 update of the OECD guidelines for multinational enterprises on responsible business conduct. As Elisa mentioned, this is an instrument adopted in the late 70s that underwent several rounds of update. And the latest revision is way more specific on the environmental and especially climate change responsibilities of MNEs. It now includes a new non-exhaustive list of environmental impacts, including climate change, biodiversity loss, and others. And its language, it's much more clear in establishing that corporations should have in place a system of environmental management and should also establish and implement measurable objectives, targets, and strategies to address their environmental impacts. Interestingly, this is the first soft law instrument, to my knowledge, that gives some fine-grained definition of the climate change responsibilities of corporations that are now called upon to establish science-based policies and transition plans, including in particular short-term, medium-term, and long-term mitigation targets concerning not only the corporate group's direct emissions, but also the indirect emissions. And this is in line also with the Shell judgment in the Netherlands. Of course, companies should prioritize, according to the 2023 OECD guidelines, they should prioritize eliminating or reducing their emissions over alternative avenues such as offsetting or compensation measures. Offsetting measures can be used as a last resort option to reduce unabated emissions, but companies should first of all address and reduce their own direct and indirect emissions. Of course, they are called upon to report transparently to avoid undermining climate adaptation of communities, workers, and ecosystems. And importantly, the OECD guidelines put an emphasis on just transition, meaning a transition that takes into consideration the interlinkages between environmental and other impacts that are also the focus of the OECD guidelines, such as human rights impacts and labor rights impacts. So it is interesting to see how the OECD guidelines now have the potential to foster a holistic or integrated approach to human rights due diligence, human rights, environmental, and climate change due diligence. And this is, I think, a welcome development. There are also some interesting things to say about human rights law. I want to start from a regional system, the African system. Now, what I'm going to say, of course, does not concern an hard law development, not even a soft law development, but I find it very interesting to look at the content of the draft study recently published by the African Commission on Human and People's Rights that was open for comments until the 30th of November this year. And it's a study carried out by two of the Commission's working groups on the impact of climate change on human and people's rights in Africa. And this study takes into consideration not only state obligations, but also corporate obligations. Why? Because it is based on African Charter's Article 27 on the duties of individuals that posits that individuals have duties towards society as a whole, and that they should exercise their human rights with due regard to the rights of others. The Commission, already in the Kilwa judgment of 2016, confirmed that corporations as well have a degree of human rights obligations under the Charter. at a minimum, they should avoid engaging in actions that violate the rights of communities. So let's say a do no harm principle. And the draft study confirms that if duties are required of individuals under Article 27, then it is not legally strange to require similar obligations of corporations. The study elaborates and states that corporations must avoid harm to climate or actions in response to climate change that have negative impacts on human rights. So this is a bit what I was mentioning before in relation to carbon offsetting project, but of course other examples could be made of actions taken in response to climate change that actually have adverse human rights, but also biodiversity impacts, for instance. And the draft study stresses that corporations should observe a do no harm, but also a preventative principle and a precautionary principle. Corporations should not only refrain from negatively impacting on the environment and on climate change, but they should continuously ensure that their acts and operations are in full compliance with the international commitments toward the reduction of greenhouse gas emissions. So the study explicitly talks about an obligation of corporations to reduce greenhouse gas emissions, again, very much in line with the revised OECD guidelines that refer to what is framed as a duty of result, in my opinion, to reduce direct greenhouse gas emissions and an obligation of means to minimize indirect emissions. They are called once again to publicly disclose their emissions and also to ensure effective access to remedies. So this is a very welcome development within the African system. Of course, it's only a study, but it gives some ideas on how a concept of corporate environmental and climate due diligence could be interpreted under the African Charter. Of course, extremely relevant in this field is the work of the UN human rights treaty bodies. They do not refer as explicitly to the obligations of corporations, of course. They talk more about responsibility, differentiating it from the obligations of states. However, especially the UN Committee on the Rights of the Child has given an important contribution to stressing that corporations as well have a responsibility to respect children's rights in relation to the environment and climate change. The CRC is also pretty much aligned with the Inter-American Court of Human Rights in adopting an expansive approach to the extraterritorial human rights obligations of states, in particular arguing that states should intervene on the activities that they can control because based in their territory or jurisdiction, in order to avoid those climate impacting activities from causing human rights violations outside their territory or jurisdiction. So once again, in the General Comment 26, the Committee on the Rights of the Child confirms that states should ensure that businesses rapidly reduce their emissions, that they put in place environmental impact assessments and children's right due diligence, and again, it stresses that the states have obligations in relation to the extraterritorial climate change-related impacts of businesses. And the committee also stresses the importance to consider the interests of future generations. Now, as concerns developments at the EU level, of course, a concept of corporate environmental due diligence is included in the draft Directive on Corporate Sustainability Due Diligence. It is defined by reference to an annex that lists a series of environmental law instruments. Notably absent from this list is the Paris Agreement. So the global climate change commitments are not considered to be an integral part of the environmental due diligence obligation that the directive requires of corporations. Climate change is, let's say, it's set aside in Article 15, requiring corporations to adopt a climate change plan. But there is no clear requirement, fully fledged requirement upon in scope corporations to carry out a fully fledged process of climate due diligence. Corporations must assess whether climate change is a relevant impact for or of the company, and if so, if they find it to be a prominent impact, then they should include in the climate change plan reduction obligation, emissions reduction commitments. However, this is to a large extent left to the discretion of the company. In addition, the current draft of the directive includes important exceptions for the financial sector, which is also problematic because, of course, the financial sector could and should play a prominent role in fostering the necessary sustainability transitions. Of course, the current draft of the directive is not the final text of the directive. It is now undergoing trialogues among the Parliament, the Council, and the Commission. And the final text is expected to be adopted early next year. It remains an important and welcome development, but in relation to environmental and in particular in relation to climate change due diligence, it certainly has limitations. I will just briefly conclude with some final observations. So, drawing the conclusions from this presentation, I would say that there are some encouraging trends. Very promising and interesting is the progressive work of certain international and regional human rights treaty bodies. Of course, emerging environmental due diligence requirements at the domestic and EU level are also a very welcome development, albeit with the limitations that I have highlighted. Further clarity might come from environmental and climate change litigation. Just to give you an idea, these are just some of the cases that are starting to clarify in some jurisdictions the responsibilities of corporations in relation to climate change. Of course, clarifying corporate environmental and climate change due diligence cannot be left to the courts, but sorry, I'm trying to go back. But of course, some interesting indications might also arise from that. We will have also to monitor the request for advisory opinions that have been filed in recent years to the ICJ, the Inter-American Court of Human Rights, and ITLOS. These, of course, are centered around the obligations of states, not of corporations, but interesting conclusions might potentially emerge from those advisory opinions if they will be adopted. Of course, several challenges remain. As I was mentioning, it is not entirely obvious yet that states are ready to walk the talk on the right to environment and on climate change, as shown by the Business and Human Rights Treaty process. So the focus on corporate liability and accountability that is really much needed should not overshadow the primary duty and obligation of states to indeed adopt the necessary regulatory frameworks and give the due weight to the right to a safe, healthy, and clean environments. A risk of corporate capture persists, of course. I'm thinking now of several international processes, including, to go back to the law of the sea, the current discussions around authorizing deep seabed mining, a process in which civil society organizations are not much represented, and in which the weight of big multinational corporations interested in starting this activity is undoubtedly strong. So obviously this imbalance in representation in the key international processes should always be a point of attention. And finally, of course, a fragmented approach to due diligence can lead to perverse outcomes, meaning that if we fail to take human rights, environmental and climate change due diligence into account in a holistic manner, the risk of indeed counterproductive outcomes is heightened. I will stop here and I thank you for your attention. Thank you.
All right, Chiara. Okay, thank you very much. We will now move on to the comments / questions / extra information from Armando and Vladislava. I'll first give the floor to Vladislava. She is here a guest lecturer at the University of Lisbon School of Law and a research here at our research center. She's the Eastern Europe and Central Asia Research Assistant at the Business and Human Rights Resource Center and very much dedicated to this topic of business, human rights, and we're trying to hold her also to environmental protection. So go ahead.
Thank you very much. Good morning, everyone. First, I would like to congratulate on the organization of the event and thank for the opportunity to join the discussion and to share some of my thoughts on the topic. Could we please share the PowerPoint? And the topic that I decided to discuss today will be one of the challenges that are arising nowadays, which is not that much of a challenge and is not that much of a new topic, but for some reason it has erupted recently. And I called it Bermuda Triangle, thank you, business, environment, and armed conflicts. And to be honest, I'm completely sure that it is a Bermuda Triangle. As soon as we enter it, I think there is no way back. So, as it is known, companies' operations are always connected to complex environments, even in peaceful times. And it gets even more complicated when it comes to cases of armed conflicts because of the danger that they bring to people who find themselves on the territory where such situations occur. And very banal question, but I will still pose it here. Why is it relevant to the environment? And the response is obvious. Any armed conflict brings a significant damage and destruction to the environment. The guidelines on the protection of the natural environment in armed conflict created by the ICRC reveal that most major conflicts between 1950 and 2000 took place in biodiversity hotspots, putting delicate ecological balance at risk. Countries experiencing conflict are also on the front line of climate change. 12 out of 20 countries that, according to NDGAIN Country Index, are the most vulnerable to climate change are also sites of an armed conflict. If we look back at the armed conflicts that happened over the mentioned period, we will find lots of examples where nature was directly harmed. For instance, the use of herbicides during the Vietnam War, the burning of Kuwaiti oil wells during the 1991 Gulf War, the extensive deforestation during the conflicts in the DRC, threats to the environment due to mines flooding in Ukraine. These all led to leads to the necessity of heightened respect and protection of the environment. As we know, and it has already been mentioned by both of the speakers previously, the United Nations Guiding Principles on Business and Human Rights in Principle 17 mentioned that in order to identify, prevent, mitigate, and account for how companies address their adverse human rights impacts, they should carry out human rights due diligence. And Principle 7 states that since the risk of gross human rights abuses is heightened in conflict-affected areas, action by states and due diligence by business should be heightened accordingly. And Principle 23C highlights that in all contexts, business enterprises should treat the risk of causing or contributing to gross human rights abuses as legal compliance issue wherever they operate. So in conflict-affected areas, all companies should move to the rails of heightened human rights due diligence by adding to the classical one, the conflict-sensitive approach. And just on these slides, you can see the process and how it is different from the process of heightened human rights due diligence and how it differs from the classical HRDD. So to close the gap that has already been mentioned, which is the fact that unfortunately UNGPs do not directly mention environment in the text, the ILC published the draft principles on the protection of the environment in relation to armed conflict, the so-called PERAC, in 2022, which aims at enhancing the protection of the environment in relation to armed conflicts, including through measures to prevent, mitigate, and remediate harm to the environment. The draft principles share the key, let's say, elements of the UNGPs, which is corporate due diligence, corporate liability for harm, and the provision of effective procedures and remedies to address such harm. For instance, the draft principle 10 mentioned that states should take appropriate measures aimed at ensuring that business enterprises operating in or from their territories or territories under their jurisdiction exercise due diligence with respect to the protection of the environment, including in relation to human health when acting in an area affected by an armed conflict. Draft Principle 18 addresses the fact that states should take appropriate measures aimed at ensuring that business enterprises can be held liable for harm caused by them to the environment, including in relation to human health in an area affected by an armed conflict. So the question is, what does the only internationally binding instrument for business which operates in conflict-affected areas say? But unfortunately, for some reason, business always forget that international humanitarian law binds business and creates some obligations towards business. Article 55 of the additional protocol to the Geneva Convention stresses that care shall be taken in warfare to protect the national environment against widespread, long-term and severe damage, and that this protection includes a prohibition of the use of methods or means of warfare that are intended or may be expected to cause such damage to the natural environment and thereby prejudice the health or survival of the population. Article 14 of the second additional protocol to the Geneva Convention prohibits attacking, destroying, removing, or rendering useless objects indispensable to the survival of the civilian population, such as foodstuffs, agricultural areas for the production of foodstuffs, crops, livestock, drinking water installations, and supplies and irrigation works. There is no internationally agreed definition of the natural environment, which is used in Article 55 of the Geneva Convention. The guidelines that I already mentioned at the beginning of my presentation understand it as the natural world together with the system of inextricable interrelations between living organisms and their inanimate environment in the widest sense possible. The notion of the natural environment under IHL includes everything that exists or occurs naturally, such as the general hydrosphere, biosphere, geosphere, and atmosphere, including fauna, flora, oceans, and other bodies of water, soil, and rocks. The natural environment includes, moreover, natural elements that are or may be the product of human intervention, such as foodstuffs, agricultural areas, drinking water, and livestock. So the harm to the environment during armed conflict can be done directly and indirectly. The first one refers to cases such as contamination of water, soil, and decrease in air quality due to fighting and attacks on a certain territory, forest fires as a result of bombings. And the second one refers to cases among which is deforestation and exploitation of natural resources as ways of sustaining war efforts. And here comes the time to discuss how business can negatively contribute and harm the environment. Companies can harm it directly by exacerbating pre-existing environmental or climate-related problems and indirectly by, for example, participating in deforestation and mining on the territory of a conflict, providing advice and or service to a party of an armed conflict on, for example, power station construction, or sharing scientific knowledge on how to develop weapons that cause environmental harm. We can create some other examples that are connected to environment in conflict-affected areas. For example, the land grabs that involve the forcible displacement of communities, violating right to property, right to food and water, and often lead to severe environmental degradation. Land grabs can take such proportions that they amount to international crimes. In 2014, for example, several CSOs filed a communication to the ICC prosecutor, alleging that the widespread and systematic land grabbing in Cambodia amounted to a crime against humanity. The next example is forced displacement of people, which can provoke large-scale environmental degradation. For example, deforestation to meet energy and housing needs, wildlife poaching, charcoal trade as a way to earn money, exponential unplanned urbanization leading to waste management issues. Such was the case in the DRC. Another, let's say, classical and unfortunate example is London case, which is probably one of the most famous modern cases of business being trialed in courts. It is now being tried in Sweden for complicity in war crimes committed in South Sudan, where a company allegedly paid the Sudanese army and non-state armed groups to forcibly displace 200,000 people. And draft principles that I already mentioned above stress that states, international organization, and other relevant actors should take appropriate measures to prevent, mitigate, and remediate harm to the environment in areas where persons displaced by armed conflict are located or through which they transit, while providing relief and assistance for such persons and local communities. Next example, and this already has been discussed, are indigenous people and their rights. As highlighted in draft principle 5, international organizations and other relevant actors shall take appropriate measures in the event of an armed conflict to protect the environment of the lands and territories that indigenous peoples inhabit or traditionally use. Failure to provide such protection may lead to confrontations, and this happened in 2016 in Ethiopia, where the government's decision to clear forest land for an investment project led to civil and political unrest of such size that the country had to announce the state of emergency. And the last example that I will give here is pillaging. The draft principle 16 refers to the prohibition of pillage and its applicability to natural resources. And it comes as no surprise, since natural resources are driving force in different conflicts all over the world. As I have, it comes as no surprise. For instance, in the DRC, it is believed that the real reason for the protracted armed conflict ongoing since 1993 is the exploration of the country's mineral resources with many foreign companies, especially Canadian and British ones, which enter into mineral exploration deals with both the rebels and Kabila's government. And it has been also mentioned in various studies that, for example, the war in Ukraine that is going on now, has one of the reasons is also the fight for the natural resources, since Ukraine is very rich on raw materials that are necessary for the just transition. And lastly, I will mention that prevention and mitigation environmental harms should be part of heightened human rights due diligence in conflict-affected areas that companies should always companies should always remember about possible consequences for such violations under international legislation and under international criminal law, since their CEOs can be tried in the International Criminal Court under Article 25 of the Rome Statute. Thank you very much.
Okay, thank you very much. So an entirely different perspective on this topic, I have to say, unknown to me up until now. Now I'll give the floor to Armando from the Universidade Católica School of Law, but well, he's almost from here
Yes.
by now. So he's also a researcher at the Católica Research Center for the Future of Law, visiting professor at the University of São José in Macau, and the Catholic University of Lille in France. So global PhD program in law from Universidade Católica Portuguesa. And now the floor is yours, Armando. Thank you very much.
Thank you very much. So thank you very much, Heloísa and Madalena Presteiro Oliveira, for the organization of this conference and for pronouncing names in different languages. I try to help you by coming from a Portuguese university, but still not that much. And so I think I have 12 to 15 minutes, if I'm not wrong. And if you allow me, I will have a different view than the previous commentators. And for sure, I will exaggerate some of the things they said just because it's the morning and I feel empowered, and it's for the sake of the argument. That's just it. And thank you very much, especially to Professors Elisa Morguera and Chiara Macchi for their interventions, and to Vladislava Kaplina for her comment. And no, I'm sorry, I was saying all of this just to try to click on my chronometer, but now it's on. So I will take a roughly different stance on this point, because one of the things that puzzles me is, why are we discussing obligations still? Obligations should be the fabric of a legal system, but in international law, we have rights of corporations, rights of non-state actors, but it's difficult to find a widespread agreement on their obligations. Perhaps because rights are a protective talisman for non-state actors, but especially rights are a talisman for states. For instance, in investment law or even in human rights law, if a Portuguese has a problem in Spain, we don't need to get involved in a diplomatic dispute with that state. So the main reason, perhaps, or I'm sorry for exaggerating, it's not the main, but an important reason for creating rights of individuals and corporations is to decommission on them disputes with a different state. Whereas with respect to obligations, it's not a win-win situation, but rather a lose-lose situation. Corporations don't want to have that many obligations, period, under domestic or international law. And for sure that states do not want to have any kind of obligation with respect to overseas activities of their nationals. Also the host state, perhaps it's their business to host those corporations without a proper legal environment. So why would they want to have corporate obligations? But should we give up thinking about international obligations and instead resort to these non-linear soft law mechanisms as the OECD guidelines, the IFS, to look to concepts like due diligence, ESG, accountability, with some forms of basic regulation, which we can all agree on, but then in terms of content and density, it may seem too low. And perhaps if I try to start answering this, if we asked any layman in the street, do you know any judgment from international courts? Perhaps the main answer will be no, but some will say yes, the Nuremberg judgments. And there, the tribunal said that international law imposes duties and liabilities upon individuals as well as upon states, as long been recognized. So we have this landmark decision which says non-state actors can have obligations under international law. And still, if you make a survey on studies, books, or research articles on corporate obligations under international law, most of them, if not all of them, will say, no, international law cannot create any kind of a black letter obligation binding upon individuals. So what scholarship has been doing is, if you allow me the exaggeration, of course, is to throw under the bus any attempt to create a general theory of obligations, of non-state actors' obligations under international law, with a special focus on corporations. Surprisingly, the few cases where this is universally accepted are criminal law of individuals, especially, and piracy of individuals. And the arguments used, there are 3 to 4, and all of them roughly absurd. But surprisingly or not, all of them are used still today, December the 5th, 2023. First, the lack of international legal personality. Very commonly used. I have no idea why. It's premised upon that idea that we have, all of us have a kind of a disorder, kind of multiple personality disorder, and therefore we can have legal personality under domestic law, but suddenly if we go to international legal system, that has completely disappeared. And surprisingly, the same authors who acknowledge individuals' international legal personality, they suddenly say, no, but that cannot happen with corporations. We have no idea exactly why. The second argument, which is the most awkward for me, is the lack of democratic pedigree. And what scholars have been saying is, of course, there can be no corporate obligations on international law because they have not ratified treaties creating these obligations, for instance, under investment law. And surprising or not, this argument has been voiced by very eloquent and very intelligent and articulated international lawyers. Of course, that then you can ask, how could a corporation actually ratify a treaty? How could it provide consent? It's legally and even physically impossible, but this argument is still drafted nowadays. The third and the fourth, they are interconnected. And basically what authors say is there cannot be any kind, or there is not, it's different from not being able in an abstract, but in practice, there are no obligations of corporations on international law, and that will always be impossible, perhaps, because of a lack of density, namely lack of sanctions, meaning that we can look to provisions such as the Geneva Convention that Vladislav mentioned, and we can very easily extract from them states' obligations, but then where is the sanction in case of non-compliance? For states, it's difficult to find, but for corporations, they are completely absent. And that's the case even for the main examples under environmental law. Think, for instance, about the Law of the Sea Convention and the case of the marine liability for marine environmental harm, or the case of the Intervention Convention. So in all these cases, even when we have an international treaty stating at the level of primary norms an obligation of a corporation, then the enforcement and the sanction is established at the domestic level, which means for these authors that we are just to consider corporate obligations, it's more a figment of an imagination rather than something that really exists. But what if we could have something in between? Some authors point to a different theory, which I don't agree, but at least it's an honest attempt. And they say, whenever there is a domestic regulatory gap, in those cases, international law can be the first port of call. Then the theory is very detailed, announcing, for instance, when the legal good being protected is important enough, trying to assess what are the means available at the domestic level. And in the end, this theory of the domestic regulatory gap is more kind of a denial than actually an acknowledgement of the corporate obligations under international law. But in fact, if we think more carefully, there are cases where international law is actually better positioned than domestic law to regulate corporate obligations. Think, for instance, about human rights and slavery, business, which of multinationals, which needs to rely, I'm sorry for the bad word here, bad verb, but which relies on transnational movement of persons, be them qualified technically as slavery or any other category. And in other cases, states may be unwilling or actually completely unable to regulate corporate obligations in specific businesses. So a different question could be, is there nowadays a general theory of corporate obligations under international law? And the answer is obviously no, there is no such thing. But in case any of you wants to do a PhD on international law, this is a good topic for sure. In the next 20 to 13 years, this will be something to be discussed and fleshed out what is the general theory of obligations of corporations under international law. But still we have 4 things that we can have for granted. First, corporations, there is no dogma against corporate obligations under international law. Provided they are compatible with their corporate nature, there is nothing against international law provision establishing an obligation which needs to be complied with by corporations, and not only at the ex ante position, but also with regulating, for instance, sanctions and ex post facto responsibility. This is quite visible in the environmental case and in climate litigation, where we have seen nowadays some courts, especially at the domestic level, of course, saying that they will enforce something against a corporation because there is a certain rule already in place at international level from which we can extract this obligation binding upon corporations. The point here is of having a non-monolithic view of the claim, perhaps following the Urbaser case against Argentina, if I'm not wrong, an investment case, where the arbitral tribunal was able to distinguish between entitlements that flow from the same right, which can only be opposed against the state, and others which can naturally be opposed against the corporation. Second, we can also take for granted that it needs to be compatible with their corporate nature, and it needs to be sufficiently characterized. And that's the main difficulty that we have nowadays, in the sense that it's important to have in mind who needs to perform, what needs to be performed, when does it need to be performed, who will be the creditor of that obligation. This is the main difficulty of international law, especially at the level, this is the third point that we can take for granted, at remedies. International law, because it's not equipped with courts and tribunals, at least as sophisticated as domestic law, is not able at all to enforce these obligations. But the fact that there is no remedy established at the level of secondary norms does not mean that we don't have a primary obligation binding upon corporations. Perhaps the key here is that idea that comes from the Law of the Sea Convention of the sponsoring states. Domestic law can be the help for international law precisely to enforce these obligations coming from international law. And in fact, states at their domestic level, they are better positioned and better equipped in general precisely to enforce these obligations. And fourth, this is something that I think we can also take for granted, but which is very difficult in the end. It's a matter of interpretation. Because if we look carefully to the wording of a treaty-based provision, we can take the Geneva Conventions that were exposed in a PowerPoint slide by Vladislava Kaplina, but if we also look to Articles 2nd or 3rd of the European Convention on Human Rights, they don't address individuals. If you have a traditional reading of them, they just target states, and they appear to create rights and duties between states. But if we read between the lines, that's where we can find a dormant life where rights can be assigned to individuals. And then we have Article 34 that enlightens everything. But there are different views. The African Commission this year, someone mentioned this, made a study explaining corporate obligations in relation to climate change. But before that, the Inter-American Court of Human Rights explained in an advisory opinion regarding labor's rights that all provisions of the Inter-American Convention at the level of primary norms, they address not only states, but also corporations and other non-state actors, meaning that it's possible to have a different reading of a treaty-based provision under which corporations, at least at the level of primary norms, already have obligations under international law. If we take this view, are we better equipped than if we resort to the theories and doctrines of due diligence and corporate social responsibility and etc.? I'm sure no. It can be a game changer in domestic litigation, but perhaps that's just it. And it can be very helpful in avoiding or at least creating kind of a barrier for case of deregulation when the industry, when the business itself claims to be the main source of inspiration for what is our understanding of due diligence, etc. But in the end, unless we are able to develop more this idea and the doctrine of corporate obligations under international law, perhaps the best thing we have still is to look to these non-linear instruments that we have nowadays under the OECD guidelines, the IFS, etc., IFS standards, etc. So the question should not be, should we give up traditional international law? We shouldn't, we must develop it. But the question for the short period should be, how can we develop more these non-linear instruments so that we have at least something available for us to provide answers for the current problems. Thank you very much.
Okay, thank you very much. Yet another perspective. So all of the speakers' commenters address different topics. So now the floor is open for questions and comments, also from Elisa and Kiad, of course, if they want to add things, because different things have been said. So the floor is now open for questions or comments. Yes, go ahead. Do we have a microphone? So that people online can listen to your question.
Hello, good morning. My name is Antonio, and I wanted to ask by your speech that states under the international law, companies have no obligations, and states don't want to do that compromise in signing those obligations. But what do you think about the proposal of the Corporate Sustainability Due Diligence Directive? Will that be a game changer, not only under the European Union, but it can be a step forward in the international law? I wanted to know your opinion. Thank you.
Okay, thank you. Anyone else wants to add a question at this point? Yes, Matteo, of course. Go ahead. Yes, always.
Yes. Thanks, everybody. Matteo Fermeglia here, Amsterdam University. I have a question it can be directed to all of you. Perhaps also primarily to Armando about the international law perspective, but again, throw it all in the room. I wonder how would you contrast this kind of approach that is emerging, especially with regard to greenhouse gases emission reduction obligations of companies, which is arguably taking the spin towards regulating production as a whole versus coming up with a full-fledged set of obligations, because as you said, we have this non-linear set of soft law, which in my eyes provides for room for leeway within the current socio-economical system where we are now. So just simple question, how do you contrast this sort of focus on, for example, fossil fuel non-proliferation treaty, Colombia signed up for that at COP28. So this push that is being driven also by legal academia in this respect versus a proper establishment of a set of obligations of individual corporations as they operate, for example, in the energy sector, which is obviously impactful from a social, economic, and environmental and climate perspective. I have been sort of struggling with this. I wonder what is more in line with international law, what is more feasible, what is more effective in terms of delivering benefits across the board. So again, I'm throwing this all back to the speakers panel.
Okay, thank you. Chiara raised her hand. Would you like to ask a question or more of a comment?
Yeah, a bit of both, because I'm really sorry, but I need to leave at 12, so very soon. So I would like to take the opportunity to, first of all, thank all the other panelists and the audience. And I wanted to briefly address Armando's speech that I found really interesting. And of course, I am familiar with Armando's book. So, and with your argument also more revolving around corporations' legal capacities than around a monolithic idea of international legal personality for corporations. And I absolutely agree with you that the next step should be to reconceptualize corporate obligations under international law. And in this respect, I think this also pretty much links to some extent to Vladislava's intervention, because I think this reconceptualization, for instance, I mean, one of the questions that should emerge from this intellectual and legal work would be to understand how the human rights obligations of corporations will then be articulated, going beyond a narrow reading of their obligations or responsibility as a do no harm obligation or responsibility, but also perhaps conceptualizing to what extent they contribute or should contribute to the fulfillment of human rights. Because I'm thinking of those scenarios, emergency scenarios, war scenarios, but also in more ordinary circumstances, some multinational corporations with their global supply chains really play a pivotal role in providing services and goods, and arguably are essential to the state's fulfillment of certain human rights. So to me, it will be really interesting to see how that human rights obligation in the tripartite categorization of respect, protect, fulfill would look like under international law for private actors. So, and as concerns Matteo's comment, just briefly, I don't think the two things are in contrast. I actually think that, of course, there is a need for transformation in the way we produce, in the way we consume, etc. And states and the international community have a clear responsibility now to act and ignite those transformations. At the same time, all actors involved should be involved within a paradigm of responsibility. Indeed, what I find again a bit concerning is that the role of private businesses in the needed transformations is always framed, or very often only framed, as partnership, as collaboration, as an encouragement to contribute. But there is still much resistance to recognizing not only the direct obligations that corporations arguably already have under international law, but even the business and human rights soft law frameworks that have been now in place for over 10 years. So this is my brief take on it, and I will now listen to the others' comments, and I'm sorry that if at some point I will have to disappear. Thank you.
Okay, thank you very much. Who would like to, of course, Armando, you must talk, but everyone else. You want? Okay, then you go first.
No, okay. So thank you very much for both questions. With respect to the EU directive, well, we still need, it's a draft proposal. Let's see how it comes at the end of the process. I have many contradictory ideas. I have not a final position regarding what, if I were a member of the European Parliament, if I would vote in favor of or against. So it's better to have than not to have. It may fire back in terms of the consequences for our economies, of course. One thing that I find, it confirms one idea that I think I mentioned before, not in this conference, but in another one, something that is good news, but awful news in the end, which is it's surprising how we can have more stringent requirements, standards, rules, etc. in European Union than elsewhere in the world. And it's not because we are more civilized, more intelligent, none of that. It's just because we have this scapegoat. We go to European Union adopts directives, regulations, and then the same persons, the same ministers who went there and voted in favor, they can come back to their countries and say, oh, I don't want to adopt this measure, I'm so against it, but it's Brussels. And in fact, they agreed to it, which means that sometimes, and this is the awful news, I think, that comes from these proposals, the EU law itself it shows that democratic and non-democratic countries, they are not willing to adopt measures peoples will dislike, and so they need to outsource guilt and to say it's the fault of Brussels, it's the fault of someone else, and that's why we adopt these measures. So the good news is that at least the directive may enter into force at some point. And we also know that when we have these transnational businesses, some of them more than others, of course, it's important for the businesses themselves to have common standards that may allow them to operate or to supply goods all over the world. And in some cases, what happens is that they think the benchmark is the European Union, because if they comply with it, then they are allowed in all over the world. Can we get something close to that under this directive? We need to see. I'm not very optimistic, but if we don't try, we will never know. So at least let's have a first attempt. If it doesn't work, then we can always change. That's the good thing about law. We can always change it. And then also with respect to Mateu's question, I agree with Chiara. So they're not incompatible with each other. We can have different approaches, and perhaps we should have different, provided that complementary and non-contradictory approaches. And one of the things that I've learned coming from a law of the sea background is that in fact, in some cases, it's better to look to industries or activities, maybe different, as something autonomous from states. The shipping industry is a very good example. That's why they have specific targets for greenhouse gas emissions reduction, for instance, because it's easier actually to regulate the industry itself or the activity from international law perspective than from a domestic law. The same thing applies to air aviation. Aviation is always air, sorry. Yes. And so we can actually think about some businesses and activities which can be singled out for the purpose of regulation. And if we are talking about multinationals, that's why we have international corporate or obligations, perhaps this can be a regulatory opportunity, not to replace domestic regulation, but at least complementary to domestic regulation. Not sure if I was clear enough, but...
Okay, thank you. Elisa, I also wanted to ask if you wanted to comment or add anything to your presentation.
Yeah, I think, I thought that the other two comments were really interesting. I mean, if and that, I think, criticism that maybe there's a role of scholars in advancing this debate in the stalemate in intergovernmental negotiations is really an interesting one. I mean, I guess two things come to mind. As a scholar myself, I tend to do the work quite a lot in other areas, and really focusing maybe on state obligations across international human rights law, the law of the sea, international biodiversity law. But I find, in a way, license to do so in terms of treaty interpretation and just taking the opportunity from the fact that states do not explicitly object to a particular reading, more creative reading on international law, because they rather kind of leave certain matters in terms of the specific content and scope of their obligations to general terms in treaty law, which allows then systemic integration and that opportunity to zoom into minimum content and extent of their obligations in much more creative ways, and much, leading to stricter understanding of what their obligations are. And we might see that reading also, in the case of those advisory opinions now, in relation to climate change, but in the debate on business and human rights and business and international environmental law, we have plenty of state practice that really provides, I think, a really significant obstacle to make, solid, effort from scholarship to provide an alternative reading. Of course, the effort is still important and can make some difference, but I think this, to me, is the biggest barrier. Like, we can't ignore state practice in this area, even if it is, it's not necessarily a global state practice. We may have, again, as I said, different push and pull. And as part of that, I think something we haven't maybe necessarily mentioned explicitly yet is, of course, the rights that particularly multinational corporations have under international investment law and the whole trajectory of the area of international law, which is coming under closer scrutiny at the moment from a human rights perspective as well as an environmental perspective. We have a very recent report by the UN Special Rapporteur on Human Rights and the Environment, clearly condemning the framing and the use of international investment law and how it's, basically undermining, in a way, everything else we're trying to achieve under other areas of international law. But again, the reality is that we have plenty of state practice to support that development and practice of international investment law. Yeah, so I'm just kind of wondering, again, it's interesting to reflect around the role of scholars and, how ambitious and groundbreaking our legal interpretations are. And maybe, there are historical junctures to keep in mind. And I think, again, that role of not just engaging with legal arguments, but maybe working more and more with evidence from the natural and social sciences that can help us. I think that's where I'm hoping to go with my own scholarship, really using that evidence to challenge very reiterated state practices that we find problematic. So I see the role of legal scholars in that more transformative approach to legal interpretation and contributions to the progressive development of international law. I think necessarily something that needs to go beyond legal argumentation in isolation from other areas of knowledge production.
Okay, thank you. I have to say in the next panel, I will want to challenge this idea that specific duties are better than generic duties. I don't think they are. I'll just ask Shen to read an online question and then I'll proceed to Vlada so you can continue.
Sorry, good morning. We have a question in the Q&A and I will read it and then I have to leave because I have to give a class in 2 minutes. So this is a question from Vincent. Thanks to all speakers for their interventions. What place do you see for the recognition of the crime of ecocide as a way to impose positive and negative obligations on corporate actors? This is the first question. Then we have the other. Do you think such recognition should happen at the international, regional, or national level? I'm wondering how much leverage the ecocide recognition within the ICC could play to push businesses to implement through and transparent human rights and environmental impact assessment. So this is the two questions, and I have to leave. I'm sorry.
Okay. Thank you. Okay, we'll start with Vladislava and then Elisa and Armando. If you want to add anything, just say something.
If I'm not mistaken, during the negotiations of the Rome Statute, there were some attempts of including ecocide into the list of crimes that can be tried by the ICC. But this idea did not come through, and it restarted again because of the amount of conflicts and the influence that the armed conflicts have on the armed conflicts have on the environment. And I think that it would be a very good idea to include it in the ICC because I would say at the international level, ICC is the best mechanism because of the Article 25 and the possibility to try the CEOs of companies, as well as at the national level, since nowadays we have much more cases of the prosecution of companies at the national level. And it's much faster than at the international level. We have years and years we've been trying to adopt the Business and Human Rights Treaty, and we may take another 20 years for this, but probably at the national level it would take much faster. But can I address some of the discussions that have been going on? First, the CSDDD, and I think that it would be the best option for at least for the region, the European Union. And the companies themselves are actually very active in pushing for the adoption of the mandatory human rights due diligence. And there are some letters, petitions signed by transnational corporations, which we all know, like, I don't know, Mars, Unilever, Aldi, and so on and so forth, asking for the adoption of CSDDD. And it will be actually easier for the states, because some of the states, first of all, by adoption the national actual plans and by the adoption the specific legislation, like, for example, I don't know, Germany and France, that already have the vigilance law in France and the supply chain due diligence in Germany. And it will be actually easier because the legislation will be unified, exactly. And for at least the members of the EU, and it will include the companies beyond the European Union, because if I'm not mistaken, around 4,000 or 5,000 companies that are not EU-based will be covered by CSDDD. And as always, conflict-affected areas and some NGOs, mine included, we are trying to push for the conflict inclusion in the CSDDD, since conflict operation, and as we are talking about, war in Europe is extremely important. And the last one on the subjects and the discussion that has been going on and the obligations. And here I will reference to Nadia Bernes, who mentions that if we are saying that people, for example, have obligations of abstaining from committing genocide, it doesn't make sense to not put these obligations on companies as well as legal persons. So at least these obligations they have, as well as international humanitarian law. But the debate that has been ongoing regarding doctrinal about around the subjects of international law, they usually say that we are trying to squeeze the international actors in a state-like subject.
Matrix, yeah.
So we are trying to put a square form pin into a round form pin. So this does not work, and we should go beyond to the positivist approach towards the understanding of the subjects of international law, and at least recognize that companies can be like secondary subjects, like they have not full subjectivity, let's say like this, because at least they have rights, they have some obligations, and they can submit claims to the international level, like, I don't know, ECHR.
Yes.
Nowadays.
Okay, we have officially ran out of time, so do any of you have to say something, really bad? You just have to say something? Or can we wrap this up?
You can.
We can? Okay, perfect. Thank you all for this once again.